Mr. Thornton gets his seat. I'd like to ask Don, Councilor Garvin, if you'd do the same thing.
Father in heaven, creator of all things, we thank you for this day. We thank you for this special time of year. Everything comes to life. We ask now that you would bless each of our committee members, our leader, be with our guests, be with our country today, be especially with our elected leaders of our nation. Forgive us for our sins. In Jesus' name I pray.
Amen. Thank you, Mr. Garvin. Okay, we'll ask Shelley to call roll.
Meredith Rayleigh. Bill Anglin.
Here.
Bill John Baker.
Here.
Jack Baker.
Here.
Harley Buzzard.
Here.
Julia Coates. Bradley Cobb. Joe Crittenden.
Here.
Jody Fishinghawk. Here. Janelle Fulbright. Here. John Garvin. Chuck Hoskin Jr.
Here.
China Glory Jordan. Curtis Snell. Curtis Snell. Chris Soap.
Here.
David Thornton. Kara Callan Watts.
Oh, honey.
Thanks, Shelley. We can do these individually, or we can do them Hoto here on primitive list.
I make a motion to approve all three.
Have a motion and a second. All in favor?
Aye.
All opposed? Passed. Okay, we'll move into our reports. The first one is Sharon, right? Are you here, Marshall, folks? Do you want to state your name? For the record?
Yes, I was going to say, for everybody that does not know me, I'm Lieutenant Don Bowen at the Marshal Service, standing in for Sharon. The report has been submitted. I have nothing further to add to the report. If you have any questions, I'll be happy to try to answer those.
Does anybody have any questions of the Lieutenant? No? Thank you. Oh. No? Okay. Thank you. Good report. Attorney General, Diane.
Good afternoon. I think the only thing that I had to add to our report, we're getting ready for Sovereignty Symposium next week. A few of us are going and speaking. It's on land, wind, and water, so it's looks to be a very interesting conference this year. We also are looking at, we've heard of 2 or 3. We've actually had only one come into the office where someone was fishing within the 14 counties and got a citation even though he presented his blue card. So we're considering whether or not to take that, represent him, and present our arguments. We probably will. It's in Sequoyah County. So we'll see how that goes. I'll keep you all apprised. I'll be happy to answer any questions that you may have.
Councilor Buzzard.
Diane, we know just recently that we had joined the state of Oklahoma with the litigation on the water rights that the poultry companies are having with the state of Oklahoma. And this is like for you to inform the rest of the committee and the audience that has listened to us why we did that and what our strategies are for that.
What we did was enter into an agreement with the state of Oklahoma that they could proceed in the water case without us and without assigning any of the resources to them, which of course we couldn't and wouldn't do. We assigned any right of action that we might have against the poultry companies to the state to go forward with. Now, the judge may or may not accept that. He may still want to get us in the case. We did that for a number of reasons. It represents a big step for us in our push to have our water rights acknowledged within the territorial boundaries of our nation, because it's the first time we have something on record with the state of Oklahoma acknowledging that we have, I believe the term that we use is substantial yet undefined rights in the water within northeastern Oklahoma, or to the Illinois River watershed particularly. So we get an acknowledgement from them that we have rights to the water. We don't have to get into the lawsuit and fight against those numerous defendants. It would be a very costly and prolonged litigation. It already has. And if we entered at this point, we would only delay it, because then everything would start all over with an additional party, discovery, depositions, all of those sorts of things. Now, we may still go there. We don't know yet, but we believe that this was a step in the right direction for us and the best trial strategy.
Thank you.
Councilor Boston?
Thank you, Mr. Chairman. And we think that if the judge accepts it, there's not going to be any sort of ruling that touches on that issue that we will have wished we'd have gotten our 2 cents in.
We tried very hard to put in provisions in the second page of that agreement with the state that if that were to happen, we could jump in at any time. This does not preclude us from entering.
Thank you, Mr. Chairman.
Councilman Thornton?
We can't have any losses of the Illinois riverbed on this, or Illinois River.
I'm sorry, I didn't.
Can we not have, suffer any losses on this, or will this keep us from going back and we might be filing suit for water rights on Illinois?
It won't keep us from filing suit on water rights. What it would keep us from doing is pursuing those same defendants for those same claims of pollution. If there is an award or a settlement with those defendants, we fully expect to participate in it with the state of Oklahoma. And our primary goal is to get the resource back to where it should be and to protect the resource, along with assertion that that's our resource. So if there is some monetary damages or some sort of relief, like, you have to comply with this regulation or that standard, we'd expect to participate in that.
Any other questions, Ms. Hammond? Thank you, Diane.
Thank you.
Next up, do you have anything on GEG, Diane?
I do. Unfortunately, we received word last week through one of the Marshal Service investigators. He had been contacted by the federal authorities. They met with the U.S. Attorney's Office in the Eastern District of Oklahoma, and they have made a decision not to prosecute anyone criminally. So we are at a point now that we can proceed tribally. We are talking to the federal prosecutors about getting any information that they may have to see how we can proceed.
Any questions? Councilor Thornton?
Can you bring us something to the next meeting showing us exactly where GEG stands as far as stocks, bonds?
I'll try to.
Money they have, how much they don't have,
I certainly will.
where they're at, the bankrupt, has they answered that?
Yeah, to the best of my ability, I will. I know that they have to file those quarterly reports because they're a publicly traded company, and I also know that Ms. Bertram keeps on top of that. I'll get some information for you.
Any other questions? Thank you, Diane.
Thank you.
Next, election commission. Is there anybody here from the election commission? Tax commission, Ms. Swepson.
Good afternoon. I believe you have my report. The only thing I would add to that report is that the next tax commission meeting is June the 3rd at 4:30 in the Government Resources Conference Room. And other than that, unless you have questions, I'll try to answer those.
Councilor Thornton?
I think I understand this act that you and Bill's bringing forward on tobacco tax.
Do what now?
The act that you all are bringing forward on tobacco tax.
Oh, yes.
I think I understand it, but would you explain it, please?
Okay, the one that amends the law, all that's doing is the law before had 50 cents per carton in it, and with the new compact, the tribe's tax is $1.50. So we put some language in there so that we don't have to change it every time we either amend or get a new compact. This way the law, we will be in regulation or in compliance with whatever our compact says or that we decide. That's all that does.
I want to make sure.
Janelle?
I have
Has a decision been made about the tag agency down at Clay County?
Salsa. We are working, we're working with Career Services. We're trying to get some renovations made inside that building. We're hoping for July, but I'm not promising because we've got to do a few renovations inside to get it set up. But yes, we are planning on opening it in Salsa.
Well, our plan's still underway to close the one at Gore because I'm hearing a lot of complaints against that, and it's going to make those people really upset if you take away something from them that they have had in the past.
Right now, my understanding is that we are moving the office from Gore to Salsa. So it would be closed. They're so close together, I don't know that we can justify the overhead, because I think that when we open Salsa, it's going to pull revenue away, but I really don't know. I mean, that's something that we can discuss with the administration, but right now, that is my understanding.
Well, I've met with people at Roland several times, and they still want to make you aware that they have a building available for $1 a month that has a T1 line there.
Thank you. Any other questions? Thanks, Sherry. Next up is Vicki, self-government.
Good afternoon. You have my report in front of you. There's a couple of things that I'd like to update you on. One, I'd like to introduce to you a new staff member. Angela Thompson is joining our staff. She's been on staff for a couple of months now. She's the new self-governance analyst. She's an enrolled member of the Pawnee Nation. She's also Cherokee and Creek. She's a graduate from OU with about 15 years experience with tribal governments and about the last 4.5 or so in self-governance. So I'm really pleased to have her on board, and she's already been a significant addition to our staff, and I appreciate the work that she's already done for us. So I wanted to introduce her to you so that if by chance I'm out on travel or something, she'll be filling in to give the self-governance report. One item that I wanted to go ahead and update you on, I included in the announcement about the IHS director. Last week, Larry Echohawk, in case you aren't aware, was confirmed. So I just wanted to update you on that. As I said, you have my report. Do you have any questions?
Any questions, Vicki? Thank you, Vicki. Good report. And welcome on board. Next one is Gaming Commission. I don't see Jamie. Is anybody here? Okay. None? Okay, moving on. Convocation, Todd.
Thank you, Mr. Chairman. Convocation actually will be meeting tomorrow. Mr. Morton and I will be meeting in my office to kind of pick up where we left off. We now have a break in the action of all the other briefing that had been monopolizing my time here. But it is our hope to get it back on track. I know we're past, we hope to have a convocation by May. We don't, and I apologize for that. But we will begin that task to finish up tomorrow, and Mr. Morton and whatever other staff from the administration is welcome to be there. It's at 2 o'clock, correct?
Yes, Joe.
Okay. If I may, Mr. Chairman, take this opportunity also to inform the committee of the decision that was rendered in the Cherokee, or the Principal Chief Smith versus Cherokee Nation Election Commission and Cherokee Nation Tribal Council. The first part of the hearing was to Chief Smith asked for a reconsideration of the transfer of the case from the Supreme Court to the District Court. The District Court ruled that they are without any jurisdiction to basically reverse a decision by the Supreme Court, so therefore that motion was denied. The second motion was to reconsider whether the tribal council was a necessary party to this and whether they had standing through an official act of the council to take part. After argument on that, the court also rejected the chief's argument on that and failed to reconsider the motion. In a previous order by the court earlier that week, a couple days beforehand, the court had ordered that the creation of the staggered terms in Legislative Act 707, where one council person had a 4-year term, some had a 6-year term. The court ruled that that was a permissible exception under the Constitution, so therefore Legislative Act 707 is constitutional. He also ruled that in accordance with the Attorney General's opinion that had been submitted to the court and considering other arguments, that all elected officials, council and executive were serving their first term under the 1999 Constitution. We then proceeded to have a hearing on Legislative Act 1408. The court, after considering some initial arguments, ruled that Legislative Act 1408 needed to be sent back to the council, I believe his exact words, for the election commission to take part in the apportionment or the counting of citizens. Legislative Act 3905 initially gave the election commission the right to apportion every 12 years from 1990. Although it was my argument to the court that the next time the election commission would be scheduled for apportionment would be in June of 2014, and that the act specifically did not require any other action from the election commission other than on that time cycle, the court felt that if we were going to establish new districts, that it should have been involved. The court recognized in its dictum or statements from the court that the right to create districts is the right of the council. Clearly, the Constitution says that. Nicolay versus the Cherokee Nation says that. And basically, it's going to be up for the election commission now to confirm or get the numbers that I believe this council's already gotten. But I am going to need the guidance from this committee. I don't need to have it today, but although I will want it in writing from each of you, what you wish, how you wish to proceed. We have a right to appeal 2 of the 3 issues. Obviously, you don't have a right to appeal an issue that you've won, which is the staggered term issue. There are some that believe that you are not on your first term. I will answer to the majority of the body if that wishes to be appealed. If not, that's fine too. And I will need to have direction from the committee or from the council members on whether you would want to appeal the districting decision from on Legislative Act 1408. And with that, I would just open it at the pleasure of the chair to entertain any questions.
Councilor Hawson.
Thank you. First of all, did the election commission argue? Did the judge essentially adopt the election commission's argument with respect to its role in redistricting? I can't recall what the election commission.
Pretty much, yes.
And I expressed to my fellow councilors that I firmly believe that we ought to appeal that decision, and it really has less to do with redistricting than it has to do with the integrity of the council as an institution and whether we want to allow a district judge to read something into the law that's not there. And anyone who's concerned about judges doing that in cases need to take a close look at this decision when it actually comes down. And obviously, we can all read and have read Todd's memo, but I hope that we appeal this, and I think we should prevail. I guess I'd put that in form of the motion, although we haven't seen the actual decision. But based on your summary of what the judge said orally, then Is it
Many of the
premature to do that at this point?
Well, many of the counselors were there, and we purposely wanted Judge Fight to write the order. Know that in our 30 days would begin from the date that order is submitted. The order on the other two issues have been submitted in writing, so that clock is ticking. But I guess I will answer to the majority of the council, although there was there was an argument that this council could only act through resolution and act. That argument was not adopted by the judge in this instance.
Well, then you asked for specifics from each council member, but to the extent that we simply want you to appeal that ruling on redistricting, do you need any more specifics other than we want to direct you to appeal that on the basis?
No, that would be fine. I mean, the permission from this council to have us intervene in the act itself took place in a rules committee meeting. So on that particular issue, it would be appropriate for a motion and a second.
I'll put that in the form of a motion.
Mr. Chairman,
Councilor Garvin?
I think we need to amend the agenda to get this out official first.
That would take away one argument.
I make a motion, we amend the agenda to take this.
Second.
We have a motion, we have a second to amend the agenda. Let's vote on amending the agenda. All in favor?
Aye.
All opposed? Okay, now, we'll act on...
And I restate the motion to
Okay.
appeal as to that one issue, the redistricting.
Second. All in favor of Councilor Hoskins' motion, say aye.
Aye.
All opposed?
Aye.
Yeah.
Julie.
Okay, next I have, Kara, you're next.
I'm fine, thank
Okay.
you.
Councilor Garvin, is that what you wanted to bring?
Yes.
That was what your question was? Okay. Okay, any other questions? Todd?
I just got to say, Todd, tell me if I'm wrong, yes, no. In a nutshell, district court judge told the council what we needed to do.
Yes.
Okay.
If I'm limited in one word, I would.
Yes.
Which is against my nature.
Is that?
Yeah.
We just need to clarify Julia's vote on that. Julia, can you hear us?
Julia, can you hear us?
Julia?
Aye.
Oh, is it Tyner?
Yes,
Is it Tyner?
yes, my vote. Yes, my vote was yes.
Councilor?
Mr. Chair, maybe it would help if she turned her camera on so we could also see who it is.
I don't think she has a camera. She wasn't that techy.
Okay.
Julia hasn't signed in, right?
Okay.
Got it.
We're all clear?
Who clears mine?
All right. Thank you, Todd. Okay, there's no old business. New business, Sharon, you want to talk about the, no, that's not you. I'm sorry. You just flipped the page. The old business is the travel act relating to tribal council repealing the old act.
Move.
Can we hear from our attorney, Mr.
Sure.
Murray?
Todd, you
Yes.
want-
Travel act. Yes.
This is repealing all of them. Todd, you want to?
Yes. Mr. Chairman, excuse me.
I guess for clarification purposes, I think Brad was going to make a motion so that we can listen.
Move that we approve.
And I'll second.
We've got a motion and a second.
Okay, discussion.
Okay.
Thank you, Mr. Chair.
Mr. Chair, yes, this act was brought about by some concerns that initiated with an email from Melanie Knight, the Attorney General's office had kind of made also a informal opinion based on some inquiries from Speaker Fraley. With that regard, I am in concurrence that there are some acts out there that need to be repealed in order to implement the travel policy that's been passed by this council. After considering, after talking with the Attorney General's office, what our recommendation is to repeal Title 19 Cherokee Nation Code Annotated 21 and Title 19 Cherokee Code Annotated 22, Section 22, and Legislative Act 5-95. The two codificated acts or sections would take care of anything that had been previous, and the research has been done on that. Legislative Act 595 is still out there that needs to be repealed. So I would ask for an amendment to the act in question to basically repeal those acts.
So moved.
Okay, we have a motion second. All in favor? Aye. That is an act, so acclamation.
Well, that vote was basically on the amendment to just include those acts. So now
Do we have a roll call on that? Or?
That was just on the amendment. Now you're on the act as a whole. So you can continue discussion or you can call the question. But yeah, that is a legislative act that would require a roll call vote.
Okay. Question, Councilor Hall.
Todd, is it necessary? Section 4 and 5 restates what we passed. Is that true? Is there anything new in Section 4 and 5?
No.
Is it necessary that we? I just wondered why it was necessary to include this. I mean, the chief vetoed it once. He'll veto it again. I suppose he could veto the repeal, but I didn't see.
Okay. Well, we're not going to repeal the latest act.
Well, I understand that. We're repealing specific acts that preceded what we did last time.
And he does have the right to
and we're just restating what we've already passed.
Correct.
And I just wondered, there's no particular harm in doing that. I just wondered what the particular benefit was.
Oh, I think it's out of an abundance of caution and to clarify the legislative history on it. That we're, the idea is to have the council develop its own policies internally.
Very good. Thank you.
Councilor Pope.
Yeah. Chairman, could you review, or maybe Todd can, what our current existing intention is on the travel policy as far as how this conflict, or how the most recent legislation that was passed conflicts with these resolutions and acts here?
Well, the act set out, specific amounts. Okay, saying, I believe, and Chrissy may help me on this. $400 mileage, and some that were just on plain expenses incurred. Your travel policy is setting a monthly travel allowance, which would be above the figures that.
Did they determine when that was to be issued, or when it started, or?
Well, I thought it was a month ago.
Well, it was approved when it was approved by this body in accordance with the legislative act. Now, again, out of abundance of caution, the speaker has put all travel on hold until we get this right. And this is an attempt to clarify any legislative counters, if you will.
So nothing has really started then until all this is,
yes,
this housekeeping takes place. So, thank you.
Nothing.
Call for a question.
Okay, call for the we've had a call for the question here. This will be a roll call vote.
Arlie Buzzard,
Yes.
Bradley Cobb,
Yes.
Joe Crittenden,
Yes.
Jody Fishinghop,
Yes.
Meredith Bradley, Janelle Fulbright,
Yes.
Sean Garvin,
Yes.
Chuck Hoskin Jr.,
Yes.
Tina Glory Jordan, Tina,
Yes.
Curtis Snell,
Yes.
Christo,
Yes.
David Thornton,
Yes.
Kara Cowan Watts,
Yes.
Bill England,
Yes.
Bill John Baker,
Yes.
Jack Baker.
Yes.
We have 15 yeses
15 yes,
and no nays.
0 no's. Okay. Moving on to the next item. This is your share. You want to?
What this act does is it is what Mr. Thornton was talking about earlier. The current law states that we have a 50-cent per carton tax, and then it says a 5% on the tobacco, and this is just bringing our law into correlation with the new compact and fixes it to where that every time we make a change in a compact amendment or whatever, we don't have to change the law.
Move for approval.
Second.
Got a motion and a second. This is an act, so roll call vote. Or is there any discussion? See that? Okay.
By acclamation.
By acclamation. All in favor?
Aye.
All opposed? Passes. Thank you. The next one is Councilor Bill John and Karen here. Speak to that.
I would move for approval for discussion.
I will second with an amendment. There was something left out. You should have a copy in front of you, and it's section 7.E, and it's to publish electronically, at least on a quarterly basis, copies of council meeting minutes and travel expenses of elected officials on Cherokee Phoenix website to fulfill the intent of previous legislative acts requiring such publication. And it just sets a minimum of quarterly.
That's the blue part in the middle of the third page. And I do accept that.
Thank you very much, Council Baker.
And this is pretty much just housekeeping and changing it so that they can do not just print, they can do it electronic media. They can, it does change the makeup of the board to where the chief would appoint two and the council would appoint two, and those would all be Cherokee, and then the four would appoint a fifth one. And short of that, I don't know that there's, they changed it to executive editor, instead of editor, to be more specific in what was going on. And it does have a stipend for the board members. Any questions?
Madam Secretary, do you have anything?
I was just going to offer that Brian Pollard is here to answer any of your questions about the changes that the counselor has gone over already.
Okay, this is an act. Okay. We have a motion second. By acclamation.
Call for question by acclamation.
Call by acclamation. All in favor?
Aye.
All opposed?
Aye.
Mr. Chair, can we clarify whether that was really a yes or no since there was a delay?
Tina,
Yes.
was that a yes?
Or was
Yes.
Yes.
Thank you.
Thank you. Okay, the next item on the agenda is Councilor Hoskins. This is yours. Christian Hoskins.
Thank you. I don't know.
Motion.
On the discussion.
It's just discussion. Okay.
Well, Mr. Chairman, as you know, the Constitution includes a provision for a delegate to the United States Congress pursuant to some treaties, and I don't think they've been passed out, but I'd ask Robbie to print out a list of questions that I had posed to Secretary Knight, and as it happens, the administration's already done a considerable amount of work on this issue, so really what I just ask is that Secretary Knight come and address those 6 or so questions that I had, and of course expand upon anything you'd like to. And sorry that the questions aren't passed out, but your review will show what those questions were, I don't doubt that. So if that's okay, Mr. Chairman.
Sure. Counselor Cobb?
After Nolan.
Okay, after she finishes, okay.
That's one be on the list after Nolan. That's all right.
Oh, you want to be after, you don't want to ask right now?
After would be fine. Thank you.
I do have a PowerPoint, but I'll allow Greg to just catch up with us however far I get ahead of him. But I'm handing it out now so you can follow along. Essentially, I just wanted to provide a briefing as to what we've done, and I think in the course of that, I'll be answering many of the questions, if not all of them in some way, that the Councilor Hoskin has posed. Just as a way of background, Chief Smith made this a renewed focus for us at the beginning of the 1999 term, so there's been many years of work done on this issue and how to advance the delegate to Congress. It's been assigned generally to Melissa Gower, who's in government relations, who has shepherded the work with the attorneys, but there's been involvement from the AG's office, Chief's office, and a lot of different folks on the issue. We've included research on the history of the delegate, the context at the time it was done, legal research on many of the issues on getting the delegate seated and what the delegate means, and then legislative strategy about how do we practically get it moving in the U.S. Congress. So, of course, if you flip over to page 3, and the provision we're concerned about is the Treaty of Minnesota primarily, and here's the language specifically from the Article 7 of the treaty, the end of that stating, it is stipulated that they, meaning the Cherokee, shall be entitled to a delegate in the House of Representatives of the United States whenever Congress shall make provision for the same. So to us, very clear that a delegate was included in that treaty. And so, given our research, I just wanted to present some of the findings of that research, some of the legal and legislative issues. So by way of history, there are currently 5 non-voting delegates to the Congress in the House of Representatives, and you can see them there: District of Columbia, Puerto Rico, Virgin Islands, Guam, and American Samoa. Each of these were created by separate statutes enacted between 1900 and 1978. They're not identical, they're all separate statutes, but they do have a common theme in that the delegates maintain a seat in the Congress with the right of debate, but not the right to vote in the full House of Representatives. The number of delegates for a specific area for these 5 are not based on population like they are in the states, but they are one member to represent more of the interests of that unique geographic area. So like American Samoa being very small, Puerto Rico being sizable, they each have an equal number, meaning one delegate in the House of Representatives. It's not based on population as it is with the states. The powers of delegates, as I sort of indicated, they have rights of debate in the House. They have no rights to vote in the full House of Representatives, but they can serve on standing committees in the same manner as the members, and have the same powers and privileges in committee as the other members of the House. So going back to Cherokee Nation, we had some very early interaction on what was considered a deputy to Congress in the Treaty of Hopewell. It's worded a little bit differently than the Treaty of Minnesota. So Article 12, Treaty of Hopewell, 1785, that the Indians may have full confidence in the justice of the United States, respecting their interests, they shall have the right to send a deputy of their choice whenever they think fit to Congress. Nothing in the minutes for the Treaty Council describes the provision. We could find nothing that described what was meant by a deputy to Congress as opposed to a delegate. However, the meaning of the word deputy in the Treaty of Hopewell was debated in the case Cherokee versus Georgia in 1831. And Justice Marshall seemed to support the notion that a deputy meant a full representation in the House. But the dissenting opinions in Cherokee v. Georgia were different. The dissenting opinions varied all the way from it. We don't know what it means. It could be either full representation, or it could be someone just sitting as an agent or a minister to Congress from the Cherokee Nation. And then some dissenting justices just said they did not think it was a delegate. They thought it was more of an agent. and they would be received as an agent and would not have rights of representation in the House of Representatives. So it was debated at that time what that deputy really truly meant. So to give the historical context of the Treaty of New Echota, we can see by that time the difference between a deputy and a delegate had been debated. So we knew that the word deputy was not definitive in giving us a delegate to Congress. There was increasing pressure for removal, for us to be removed west of the Mississippi. And now we had 2 Supreme Court cases out there that had affirmed our status as a government, and there was pressure from Georgia, primarily, as you all know, to remove us. So all of this is converging at the same time. And to illustrate a bit what Cherokees were thinking at the time, in 1828, the Cherokee Phoenix published a series of articles stating that the only way for the Cherokees to preserve their nation was by asking to form a kind of territorial government annexed to the federal union so as to become an independent acknowledged federal territory with a delegate in Congress and the privilege to become a state when your population will allow it. So very clearly the discussions about a true delegate to Congress with representation was being debated and discussed among the Cherokees at the time. On the next slide, we see one of the questions that Councilor Hoskin posed were about other tribes' similar treaty provisions. And the 2 that we have found are 1778 Delaware Treaty, and that one contemplated a confederation of tribes coming together and having one delegate for those tribes in Congress. That confederation never came to be, and so it never materialized. And then the other is the 1830 Choctaw Treaty, the Treaty of Dancing Rabbit Creek. In that one, the Choctaws' desire to have a delegate is discussed in the treaty, but it provides that the tribe has to make application for the delegate and that the Congress may consider of and decide the application. So it seems like there was still an ability for the Congress to decline it later. They can make application, we know the Choctaws want one, and then we'll consider it. The Choctaw and the Cherokee treaties are the only 2 that contemplated that each tribe would have their own delegate. The others were of a confederate nature, a confederation of tribes. In contrast to the Choctaw Treaty, that seems permissive. Ours uses the word stipulated. It says that it is stipulated that the nation shall be entitled to a delegate in the House of Representatives. And so we believe the words stipulated, entitled, and shall are very much stronger than the permissive language of the Choctaw Treaty, in that our case is much stronger for the delegate. I have extended an inquiry to the Choctaws. I am not aware of their efforts to advance the delegate and what kind of results they've had trying to advance a delegate, getting a delegate seated for Choctaw Nation. In the negotiations over the Treaty of New Echota, in 1832, 1833, the Department of War's removal advocacy included some promises for an agent for the Cherokee Nation. The word agent and the discussion of the word agent would be someone who would reside in Washington to communicate the nation's claims and wishes to the government, they said. There were also discussions about a delegate in a different manner to Congress. It was clear that use of the word delegate was very important to the Cherokees and to the Choctaws, and that President Jackson in his correspondence talks about using that negotiation tactic as a means to get these treaties negotiated with the 2 tribes and using it as a bargaining chip to make it happen, to close the deal. In April of 1832, the Department of War sent a letter to the agent of the Cherokees West describing the difference between a delegate and an agent. A delegate and a deputy, and expressing the President's willingness to allow us to have a deputy. And so, again, there's distinctions between deputy, agent, and delegate. So it's clear to us that eventually the use of the word delegate meant to the signers on both sides that the nation would have representation in Congress. So ultimately, the word delegate was chosen. Given the earlier provisions of deputy in the Treaty of Hopewell and the references to agents in the correspondence and the earlier versions of the Treaty of New Echota reflect to us a deliberate intent to use the word delegate and that we would have representation in the House of Representatives. Before ratification by the Senate, there was a last-ditch effort to try to change the word delegate to agent, and when that happened, John Ridge had read a news article indicating a Mr. Dickinson, and I'm not sure who Mr. Dickinson is, but it was his intent and his proposal to change in the Senate bill the word delegate to agent. So he wrote a very long, eloquent letter in objection to this, and I'll just quote some of it here. He said, "If Congress cannot swallow the word delegate, we do not desire they should give us the agent." He also said, "If you fail to obtain for us the right of being heard on the floor of Congress by our delegate, let the bill perish here." So essentially, John Ridge was willing to do away with the whole deal in order to preserve the word delegate in the treaty. So the fact that the delegate language was left intact, again, demonstrates we think both parties knew what they were signing and what was the understanding of the deal. And just as a note, Councilor Hoskin knows this quite well, in construction of law around Indian law, the courts have to construe a treaty as the Indians understood it to be. And so context, correspondence, anything that describes what the Indians understood that provision to mean means a lot when it comes to interpretation in the courts. And so that we understood and knew that delegate meant representation on in the House floor will be very important when it comes to our legal challenge if we have any on this issue. So in terms of the treaty, we call treaties the law of the land, but the delegate to Congress provision, as being part of that treaty when it was ratified by the Senate and approved by the President, becomes federal law. So it does hold the status of federal law, and there's been no federal legislation since that time to abrogate that provision. Even though Congress does have the ability to abrogate treaties by statute, they have not done so in this case. So after the treaty, what has happened since that time? We've had several acknowledgments by federal agents that were with the Cherokee after that time, acknowledging and supporting the delegate to Congress provision in our treaty. In 1836, Secretary of War reported in his annual report support for the delegate provisions of both treaties for the Choctaws and Cherokees, saying they should be fulfilled at early a day as circumstances will allow. Well, that was 1836, and we're still waiting, but at other times following that time, there have been repeated comments from agents to the Cherokees about the delegate provision in 1837, 1839, all the way up to almost the Civil War. There were several references and correspondence and reports from agents to the Cherokees. And then just as a note, by the time after the Civil War in the Treaty of 1866, the provisions of all the former treaties were protected in the 1866 treaty. So nothing that was in conflict in the 1866 treaty was expressly preserved. So that brings us forward to near the allotment era. And this was the only time that I found in our research, although I can't say it's the only time, that we formally pursued trying to get the delegates seated. In 1904, a petition from the nation was presented to Congress requesting seating of the delegate, and it got no response. So that plea went unheeded, and that at the time, as you know, we were fighting against allotment, against statehood, and the Five Tribes Act was passed to try to liquidate our government at that time. And so it was probably not the greatest time to get our delegates seated at that time, and it was not responded to. So that brings us more to present day. Of course, we had our Constitution in 1976, and then the 1999 Constitution, specifically referring to implementation and seating of our delegate to Congress and how our delegate would be designated. It demonstrates, of course, that this is high importance to us and we intend to pursue it. So in the 1999 term, Chief Smith assigned that to us to conduct the legal research, prepare a plan to implement this and get it done. So we've been developing these legal and white papers, and what I'll do is I've got copies of two papers that I'd like to distribute to you today. One is a longer legal paper with all the citations, and some of what I've presented here is documented in that for your reading. And then the other is a shorter white paper that we would use at some point to lobby and distribute to congressionals, illustrating the issue but keeping it short enough so that we don't lose their attention on the delegate issue as we go forward. So I'll distribute those to you. I've stamped them as confidential for a couple of reasons. One, we're not at the point to make legal arguments yet, so we probably want to keep those a little bit close. And then the second is it's got some legislative strategy about how we would intend to advance a delegate in the white paper. And so because it involves strategy, I'd like for us to keep it somewhat confidential at this point. Just to move forward, possible challenges. This was at least legal challenges was one of the issues that the counselor asked about, Counselor Hoskin. Possible challenges, we've gone through many of them, and they're discussed in the paper at length, so I won't go into a lot of detail here. But appointed versus elected delegates has come up as a potential issue. Our delegate is appointed. All of the other delegates are elected by popular vote. So would that become an issue at some point? We don't know, but we're prepared to deal with that if it does. Tribal support for a Cherokee delegate. Would we get tribal support? Would we get tribal opposition because they would not have a similar delegate to Congress? We don't know yet. And so that's an issue that may be out there. One man, one vote issue. And this has come up in the context of some of the other delegates, but because Cherokee Nation would have a delegate to Congress, but we're also represented by Congressman Warren, for instance. So does that mean that Cherokee citizens get more than their fair share of representation in Congress? And so we would be prepared for that kind of argument should it come up. And then we would assert that legislation is not needed to seat our delegate to Congress because the treaty has been ratified, approved by the President, and all that would be needed would be the logistics of the House to pass a rule to get our delegate seated. We would make that assertion. We don't know if the House would agree with us and perhaps say that legislation is needed to seat the delegates. If that's the case, we would anticipate that the House would want to impose all the codified law around delegates on the Cherokee delegate, and if that's the case, we'd want to review all of those laws that are out there, which may be general but may be specific to some of those territories, and how that would apply to our delegate and how we might respond to that. In terms of legislative strategy, we were very near moving this forward in a very aggressive way. We had some initial meetings, the chief had some initial meetings with our congressionals, received very favorably, and it was moving forward. And then the citizenship issue has gotten all of our attention, and so our energies and focus have been on that issue. So it somewhat has stalled based on that. But we reassess from time to time our best opportunities for continuing to advance this. So at the point that it is a good time to advance this again will probably be when you see a nomination from the principal chief for a delegate to Congress. So with that, I would be happy to answer any questions. And then the chief did stay for some of this presentation, but he had to leave. So Diane Hammond was here, who has also been involved on this work. So
I've got a couple things, if you don't mind. I would state that we're not just represented by Mr. Bourne. We also have some other representation. Which, unfortunately, I'm not in his district. But second thing is, are you, with the radical relationship change between the First Nations and Canada, are you? I don't think they have a delegate to the, and I don't think they do. And if that's the fact, have they sought any of that? Because they have some really radical change in their relationship with the Canadian government. Have they sought?
I'm not sure. It seems like I did hear at one point that they had representation in the House of Commons. I'm not sure how that works, but their relationship with the Canadian government is quite a bit different than ours.
We, as a government, since it's federal law based on that treaty, we cannot change elected versus appointed without changing the content of that treaty. Is that correct?
How the delegate would be selected is not in the treaty. How the delegate is selected is in our Constitution. So
we could actually make
change
a
it
lot
with a
of
constitutional amendment.
We could actually say we're
require
going to
that.
elect this individual.
It would, yes, it would
It
require
would
a change
require a
to our.
constitutional amendment. My next two things, real quick, if you don't mind, are this has intrigued me for years, but and I'm in full support of this. Mine boils down to a timing issue, obviously, and timing from the standpoint that if the Freedmen issue goes to court, if that's a positive outcome for the Cherokee Nation, essentially what's happening there is you're reaffirming a treaty. You're saying the treaty, a court would say, this is what this treaty says. Because that would be a real big backbone of the court case, I'm assuming. I don't want to get into court cases, but that's a treaty, interpretation of the treaty. It would be my understanding that based on a positive outcome reaffirming a treaty, you have a lot more solid footing, because then you can point to another court case and say, look, we just had a court case, reaffirm this treaty, same treaties here. So we're basically saying delegate, and we're using a treaty as a basis. It gets back to the timing issue, and that's my whole concern on this is not necessarily timing, because we had a lot of other things going on. And I'm not an attorney, so some of the attorneys would be better off answering this question. But you have a positive court case that really hinges on how you view how a treaty is read. You just have one more, bullet in the belt to get to if you're going after a delegate. So that's my whole thing on the timing. It's not because we have a lot going on, just because it's just one more thing you can say. So that's really. And the whole timing in court cases is probably discussion. I'm sure Councilman Hoskin probably has some thoughts on that. But those were just some of the things that I was thinking while you were talking. So it's all a timing issue.
Mr. Chairman, if I would, the legal strength of your argument is certainly one component of it. I think two more components of it is the legislative timing and the public relations timing, because you saw, for example, in 1904 when we tried to advance this, the timing was such that we want to integrate Indians into the mainstream. We want to dissolve their government, and so the timing of that didn't seem to be as good not because of legal reasons necessarily, but because of policy swings in the federal government. So all of that comes into play, I think, when we try to get this done.
Yeah, Secretary Knight, you mentioned that there was a question about tribal support, and I was just curious, you mentioned the Choctaws. How many nations do you believe, or can we make an estimate at this time that might have this type of language in the form of treaties? Because I wouldn't imagine it would be very many.
We think only Choctaws and us.
So we think that we're a very special, unique case, and in that instance, it wouldn't just be everyone that would be eligible that's throughout history has this opportunity or been afforded this special relationship, just as entities such as the District of Columbia or Puerto Rico, they kind of have a special place. So I was just kind of curious as to what the opportunity was for us, and you're saying that we're unique along with maybe the Choctaws, and that's all based upon the research that we've done reviewing treaties, right? Okay.
That's correct.
Thank you.
Any other questions? Councilor Hoskin?
Thank you. I got a couple questions. First of all, I really appreciate the presentation, and I didn't appreciate the depth of research that the administration had undertaken, and I really appreciate the leadership on the issue. One question is, at the time of the Treaty of New Echota, did Congress have those territorial delegates to your knowledge?
No, I don't believe so. There were a lot of different pieces of legislation proposed for confederations of tribes, none of which passed.
I guess
during
I'm
that
talking
period of
about
time.
any of our American territories.
That was after 1900,
It was
I
after
think.
that. So, in terms of what Cherokees understood to be a delegate at the time, we would look to what a delegate was, and I'm sure the white paper and the legal paper addresses that, but that seems to me to be one issue. Certainly today, we think a delegate is like Eleanor Holmes Norton, the District of Columbia.
We may have considered it to be full voting rights on the floor, and if that's the case, maybe we should advance that.
And I guess secondly, I've not put much thought or research into this, but I'm not off the cuff too concerned that the legal ruling in the Freedman case might impact our ability to assert our rights under this treaty. I do think it's a matter of politics and timing and public relations, and I think, unfortunately, the delegate to the United States Congress is, at least for the time being, fallen casualty to the Freedman issue. And it's one of the consequences, and that time will pass, and I don't know when will be the right time. Now, certainly not it, I think. So I think it's more of a practical issues that are impediments. And then, I guess, lastly, when you say you got a good response from the delegation, did that include our 2 U.S. senators?
At that point, I believe the principal chief had only spoken with congressmen, so I think it was in the House. Because at that time, our strategy was to pursue a House rule, so it was just going with the House representative.
What a horrible result if a United States senator from Oklahoma sponsored legislation to abrogate that provision of the treaty. So I wonder, going down the road, if we shouldn't check Senator Coburn's pulse on us invoking the treaty. You know, he once called treaties ancient documents, and I'm not sure how much worth he puts on a provision like this that he might consider to be so ancient as to be worthless. But we'll cross that bridge when we come to it. Thank you, Mr. Chairman.
Any other questions? Councilor Pope?
I believe I do have one more. It goes back to our decision to assign this to this guy. Could you talk a little bit about that as far as why it's assigned to this in particular?
Primarily, it boils down to, because it's never been challenged in the court, although we've done legal analysis and support for any challenges we think we might get, or to assert our rights, it primarily at this point is a political process. It is the House choosing to seat that delegate and what that process would be at this point. So it's legislative advocacy, PR advocacy probably.
Any other questions? Is that all?
I've got a question. Maybe a question for another time. I'm thinking about our Washington office as a lobbying entity. How would that relationship work if we had a delegate?
Well, that is part of what we've contemplated during this process, is that the point that it comes time to be aggressive about pushing the delegate to be seated, that the delegate should be appointed, because the delegate themselves become important. The caliber of that person, the ability of that person to do the advocacy and assist us in doing that. But yes, that becomes a very important part of our presence in D.C. at that point forward.
Thank you.
Thank you, Madam Secretary.
Thank you.
Do we have any announcements? We do have an announcement right here.
If everybody would keep Meredith in your prayers, apparently her brother is gravely ill and they passed away. Okay. I knew they were taking him off life support, but I did not know that he passed. Keep her in your prayers.
Councilor Garvey?
What's his name, Bill John?
Sid. Sid.
Sid?
Any other announcements?
Now I entertain a motion for adjournment.
So
Whoa, wait a minute.
I'll withdraw that motion.
Kelly?
I have an announcement. Speaker Fraley was going to do this, but since she's unable to be here today and had requested I go ahead and do this, I'm given a handout. Just pass it around that way. We've had, I guess, issues in the past with legislation, backup, and that type of thing. Due dates and agenda posting and mail outs, and you guys getting your packets in enough time to be able to review them before you get here. So, Speaker Fraley, myself, and Doug assisted in coming up with this plan. And what it is going to do is, I've attached actually a sample calendar for June. So our next meetings are June 15th and 16th. What you're going to do is go back 2 weeks and go to that Tuesday, which would be on the 2nd. And on that day, all the documentation and all the legislation is due. The next day on Wednesday, I'm going to comprise a draft agenda and send it to all the chairs. I'm also going to contact all sponsors and make sure that you guys are aware that you're listed as a sponsor on legislation that I receive. If I don't hear from the chair or the co-chair within the next day, by Thursday, the agendas will be posted that Friday morning as they were sent out to you in draft form. The only way they'll change is if I hear from the chair or the co-chair that changes need to be made. Once the agendas are posted that Friday morning, it'll give me all day long to get the packets together and mailed out that same Friday. This is going to allow you guys more time to review them before the meetings. The first page basically just goes through what I just said. There's holiday exceptions. If the holiday falls on a Friday, the Tuesday-Friday dates would change to Monday-Thursday. If a holiday falls on the Tuesday, then the dates would change to the Monday-Friday. And did you get yours going? Good.
Now I got the list.
I got 2 more. You can send those around. I got additional handouts here too, honey. The second page goes into the explanation of what I said about the draft agendas and contact. And if I can't get a hold of the chair, then I'm going to contact the co-chair, and you guys will have to give me the approval. If the legislation is not received by 5 o'clock on that Tuesday deadline day, it will not go on the agenda. The legislation must list a sponsor at the time of the deadline. Sponsor must have agreed to sponsor the legislation that they've been listed on. Amendments must be in red line form, underlined and strike-throughs, and committee-approved legislation will be presented to the Tribal Council at their monthly meeting in final form. If you have any questions, please don't hesitate. Yes.
Is this just resolutions and acts, or is this also community assistance, any of that, law enforcement, any of that?
All of that we continue to accept up until...
Those are already in your packets they go out in the packets already, currently. We amend them on the floor of the meeting, but they're in the packet of the deadline already.
Thank you. So, just a quick clarification question. So, this means that if anything comes up, even if it's urgent, it won't even be considered for amendment by the body or a motion to amend, or?
That's up to the chair's discretion. If I don't have it that Tuesday, if it comes to me that Wednesday, Thursday.
And I think that's very fair. Thank you for the hard work, because this looks excellent. Thank you, Shelley.
You're welcome.
Any other questions? Any other announcements? Now I'll entertain a motion.
Second.
All in favor?
Aye.
We're adjourned.